Good evening, students. Good evening, Judge Ulf Öberg. Thank you for your time. Thank you for being here. We are very glad to hold this conference at the last day of the European Union Week that we have organized with TUM School of Management. Before we start with the questions, could you please introduce yourself for a few minutes?
Yeah. Thank you. Thank you for having me. Thank you for the organizers for giving me an opportunity to speak to you. My name is Ulf Öberg. I am one of two Swedish judges on the bench of the General Court of the European Union. Very shortly about my background, I did my law degree at the University of Stockholm. Got a bit tired of law, so I went to Paris and studied political science for 2 years. And that was in the same period as Sweden joined the European Union. Worked in the government services of the Swedish government and clerked for Judge Ragnemalm at the Court of Justice at the beginning of my career. And I was a barrister, advocate, running my own law firm, a boutique law firm in EU and competition law in Stockholm for 16 years before being appointed to the bench. Today, I would like to talk to you about what I consider to be the core of the function that I've been called to carry out, which is judicial review. That is the role of the General Court, which is a court of first instance. We control the legality of the decisions of the European institutions, and in particular, the European Commission. As a starting point, let me point out that judicial review is not carried out in a vacuum. As any court, we inevitably balance and promote various sets of values and contribute to enhancing one or the other of the principles that constitute what we call the acquis communautaire, which is the common set of legislation, of legal acts, of court decision, which makes up European law. Sometimes, as you will see, the promotion of fundamental values of the European Union is hidden behind technical and factually and legally complex cases. But this, for the judge I am, is somewhat of the beauty and the privilege of working at the European Court. Out of an apparently technical, some may call it uninspiring case concerning, and you will see, capacity allocation of gas, you can discover that some more profound issues and higher principles are at stake. At the request of the organizers, I would like to talk to you about one of such values, which in the current social and economic context is of utmost importance, and that is the principle of solidarity. Solidarity is a fundamental value on which the European Union was built. It's an inherent part of the vision of the European Union in the future. It is also, and that is the whole debate before my court, and it's now pending before the Court of Justice, a cornerstone of the EU legal system, which is visible both in the EU treaties, in legislation, and in our case law. In fact, looking back, you could argue that the principle of solidarity within the EU legal system has its roots in the Roman era, where we had a notion of unlimited liability of each member of a family or a community to pay common debts, and was characterized as what in Latin is called obligatio in solidum. This was, as you may recall, part of the debate of the financial crisis, and in 2008, it's still today at the center of debate of issuing of Eurobonds and the Greek crisis at the time. In the words of D'Artagnan or Alexandre Dumas, you could say tous pour un pour tous, or as the Swiss neighbors would say, one for all for one, kind of turn it around, which is the unofficial motto of Switzerland. One issue when researching this topic is that we probably in different languages mean different things when we speak about solidarity. Looking up in the Oxford English Dictionary, the term solidarity is defined as the support by one person or a group of people for another because they share feelings, opinions, or aims. In French, solidarité, according to the Petit Robert, is the fact of being solidaire. It's a relation entre les personnes qui entretiennent une obligation morale d'assistance mutuelle. So there's a moral dimension to it, which you may not find in the English version. If you look in German, Solidarität, according to Duden, is die unbedingtes Zusammenhalten mit jemandem aufgrund gleicher Anschauungen und Ziele. And there is a notion of Zusammengehörigkeitsgefühl, a notion of community, a notion of a Gemeinschaft, which you wouldn't necessarily find when talking about the English version of solidarity. But since its inception, I will try to show that the European project is built on a notion of a shared community, of a Communauté économique européenne, an Europäisches Gemeinschaft. And if we go back to the Schuman Declaration, which I will then pull up from 1950, you will find it in the opening sentence. Europe will not be made all at once or according to a single plan. It will be made through concrete achievements, which first create a de facto solidarity. As you all know, the pooling of coal and steel would be a first step of the federation of Europe, and that would make it plain that any war between France and Germany would not be unthinkable, but materially impossible. You have here, obviously, the S word of the solidarity and the F word of federalism, which through the years have somewhat been a bit of the Voldemort of the European Union. We never say it, but it is there in the declaration. We have gone a long way since then. The Coal and Steel Union, Euratom, and the EEC have become the European Union, where solidarity is not only a means to prevent conflict, but a principle that permeates more or less, more in both, on the one hand, relationship between the member states, solidarity between member states, and the relationship between member states and the European Union. On that note, it was with great sadness and deepest personal regret that we saw, at least I saw, the United Kingdom, Great Britain, Northern Ireland leave our union last year, and more largely our community, or our Gemeinschaft, or a feeling of togetherness. And I think we will at some point, both as European judges, as citizens, as EU and national policymaker, have to draw the proper conclusions of the underlying reasons of this lack of belonging, of shared feeling of trust, or of shared goals of the British people in our union. Moving over to the more legal context, solidarity within the union and between member states is often mentioned by the Court of Justice, in the context of a principle of loyal or sincere cooperation when interpreting Article 4.3 of the Union. That provision establishes that the Union and the member states shall, in full mutual respect, assist each other in carrying out tasks which flows from the treaties. May not be Dumas, may not be D'Artagnan, but it's in there. It's the notion that of mutual respect, mutual assistance, basically. Solidarity between the member states is regulated in a number of fields, including energy, immigration, asylum, border checks, security, and judicial cooperation in civil and criminal matters. For example, in the field of energy and energy security, it is provided in the treaties that a spirit of solidarity between member states, it's mentioned in Articles 194 and 122 of the Union, as well as in secondary EU law. So where do we go from the spirit of solidarity to making that into a legal principle? That was a case on which I sat last year. So far, on a closer look at the policy areas where solidarity is mentioned as an embedded in EU legislation, it can be claimed that solidarity does constitute an underlying fundamental union value. So far, it has been considered that despite all reference in law, it is unlikely to be justiciable. It's unlikely to be hard law, basically. It's a nice declaration, but it stops there. In most cases, applicants claimed or have claimed that breach of the principle of solidarity before the EU courts, but courts, my court and the Superior Court, have preferred to address this indirectly by referring it to different concepts. As I said, principle of sincere cooperation, principle of non-discrimination. Yet things are changing, and I've chosen an example that I find particularly interesting since it has to do with a factor of production. While the EU was ultimately born out of coal and steel, I will now talk to you about gas. I'm referring to the recent Poland versus Commission case, or the Opal case, judgment of the General Court in case T883/16. This case is an apparently rather dry dispute about capacity allocation in the so-called Opal natural gas pipeline. This pipeline connects to the offshore Nord Stream pipeline, Greifswald in northeast Germany, and is a principal avenue for the distribution of Russian gas through Central Europe. In 2016, the European Commission approved the decision by the German network operator that would have allowed Gazprom, the Russian gas supplier, co-owner of the pipeline, to expand its use of the pipeline and of its capacity, potentially far beyond the 50% it had been allowed to use so far under EU rules. Needless to say, there are a number of geopolitical factors at play here that need to be explained. In particular, why the Opal pipeline had remained limited to 50% of its capacity. This restriction limited and reduced the volume of Russian gas that could be transported through the Nord Stream pipeline into Europe, thus limiting reliance on Russian gas. The Commission approved a proposal made by the German regulator in 2016 to increase the use of the pipeline, which indirectly also meant increasing the import of Russian gas through Nord Stream. Poland, for a number of reasons, was not happy with the decision. Besides the risk posed by higher dependency on Russian gas, the main criticism was that a significant part of the gas transported through Ukraine and Poland would then be redirected through Nord Stream and Opal. It brought a case before our court and made an important point in claiming that by compromising its energy security, the Commission had breached the principle of energy solidarity set out in Article 195 of the treaty. According to Poland, the principle obliged both the member states and the EU to achieve EU energy policy objectives in a spirit of solidarity, and measure that would compromise that security of certain member states would violate this principle. That was basically the argument made before the court. The Commission, on the other hand, argued that energy solidarity is a political notion and addressed to the legislative powers and not to the administration. And it only concerned a situation of crisis in the supply of energy. The first chamber of the General Court, under the presidency of former Judge Irena Pelikanova, held that energy solidarity is not a purely political notion and is not limited to requirement of mutual assistance in times of crisis. It imposes a general obligation on both EU and the member states to take account of each other's interests. In particular, the EU and the member states must avoid to take measures that can affect the security interest, the energy security interest of other stakeholders. I will be not go into further detail of the case since the judgment is appealed to the court, so it's sub judice before the court. But it tells us, if confirmed by the court, that the solidarity is not merely a political concept, but a ground for judicial review. Secondly, the principle of solidarity can be invoked before courts on its own, independently of a breach of secondary law legislation. And thirdly, there are both rights and obligations, both for the EU and for the member states. Solidarity also binds the EU towards the member states. It is somewhat a form of a golden rule. Do not do to others what you don't want them to do to you. It is fair to say that solidarity in the EU is driven not only by altruistic motives, it can also be self-interested, the result of egoistic, or in the case of member states, maybe even nationalistic incentives of instrumental significance that allows for the realization of vital political functions. This more pragmatic side of solidarity can be illustrated during the current COVID crisis, where financial assistance has been given and permitted, not because of altruism, but to avoid a crisis that might happen if there was no help at all. This kind of solidarity behavior could be framed as enlightened self-interest solidarity. On a more personal note, I would like to take this occasion to personally thank each and every one of you. Obviously, as members of a younger generation, you have shown solidarity, responsibility, resilience, and sacrifice of personal freedom for the benefit of an elder generation, more vulnerable members of the European citizenry. If that is not a sign of de facto solidarity between generations, I don't know what is. The European Union has been criticized for its common procurement and slow rollout of vaccines. And it is probably certain that if each member state would have gone it on its own, it's possible that the bigger and the wealthier member states could have accelerated things as regards their own nationals. We didn't. And if that is not a sign of solidarity between member states, I don't know what is, to be true. To sum up, in my view, solidarity is a cornerstone in the political project of the EU, as well as in the court's judicial review, and it must continue being so going forward. Just a few days, it was the 71st anniversary of the Schuman Declaration. Question is, in 2030, on the 80th anniversary, will there be another Judge Öberg who will give a speech on solidarity? And if by then, will de facto solidarity be considered an accomplished task? I don't think so. I think, like our counterpart across the Atlantic, our union is an incomplete one. I trust you will pick up that baton and do your part in the next stage of a process of creating an even closer union among peoples of Europe, where decisions are taken as openly and as closely as possible to the European citizens. Thank you very much.
Thank you for this. Thank you for this very interesting introduction. So our first question would be referring to last week. the Advocate General of the European Court of Justice ruled that the new disciplinary regime for Polish judges, established by a law passed in 2017, in Poland was contrary to European law, an opinion that Warsaw dismissed. And what would you say to people who portray, for example, the actions of the European Court of Justice as a meddling or an intrusion in the sovereignty of the country, which were words spoken by the Polish Deputy Minister of Justice, Seb Kaleta?
Well, obviously, I will be careful in commenting on cases and on declaration on cases. I had a principle as a barrister never to comment on cases which I had argued, especially unless it was in the interest of the client. But what I can say is that notions that we may have taken for granted, such as the independence of judges, such as fundamental rights, the independence of courts, and basic foundations of a liberal state are obviously not as evident as they were. Courts do not seize themselves, they do not meddle themselves into national politics. They are seized by the cases which are sent to them. So obviously, in the case of the Polish judiciary, there is an ongoing debate between the European Court of Justice and the Polish courts. That is normal. It is a deliberative process. Some may disagree with the result, but I think it is part of our common discourse in Europe. So I welcome the judgment, and I also welcome the criticism. I think that is what makes us Europeans, that we do deliberate.
Thank you for your answer. We're going to ask you about a more economic matter. So we're in a quickly changing economy, which requires Europe to constantly adapt, and otherwise its strategic competitiveness would be threatened. Competition law already makes it possible to monitor the behavior of certain governments in terms of public aid in the European level, but it does not provide the possibility of taking action against foreign companies that come in Europe on the European market, and then they find themselves in an advantageous position in front of the European company. So here, are we facing sort of a legal vacuum? And what measures could be taken to protect our markets from this quite unfair competition?
Thank you. It's a very good question. We have recently had a number of cases in my court. I didn't sit on them, on tax rulings. Obviously, while we do have solidarity within the EU, we also have a healthy competition between member states. The question is that competition also encompass regulatory competition on taxes, and that was basically the issues being brought forward in the tax ruling cases, where some member states had differential treatment or favorable treatment of a number of multinationals. The judgments are under appeal, so you will forgive me for not being very detailed on it, but obviously the tax competition, if taken to its extreme, in my view, will lead to a race to the bottom. There obviously has to be some form of level playing field. The problem being obviously that taxation is a national competence, and therefore are the state aid rules the correct way to address the issue, or is that more of a political question that would have to be resolved by the EU legislator? I will just keep that as an open question.
Thank you. And talking about maybe conflicts between countries, France is currently in direct conflict with Britain over fishing condition. I think you know about it, around the island of Jersey, of Normandy. Both countries have sent military vessels to the area, and the conflict has escalated quite a lot in recent days. The post-Brexit agreement between London and Brussels stipulates that European fishermen will have to reduce their catches of fish in British waters, but there should be a transition between now and then. And on Sunday, 2 of May, Paris denounced the new requirements, which had not been agreed, discussed, or notified, to quote the declaration. And according to you, what is the role of the European Court of Justice in those matters? And how do you deal with this type of regulatory conflicts, especially?
Well, we have lived through the existential drama of Brexit and getting Brexit done. And I think what we're now seeing is that it's probably going to take some time before Brexit is done in practice. Obviously, there is the Brexit Treaty, the issue of Northern Ireland, and issues of fisheries, which have to be sorted out. I can, as a citizen, obviously regret that we are down to gunboat diplomacy between former member states to some extent. I also understand that, French fishermen are worried about their future. How to solve this? Will this end up in our court? I don't know. I think that is obviously an issue that will have to find some resolution within the separation treaty and the mechanism to that effect of dispute resolution. But at the end of the day, it's going to have to be fixed also in this case by politics and maybe not by law. I'm not sure that this is an issue which will reach our court anytime soon, but I'll keep that open.
Speaking of the COVID-19 crisis, the European Union has become aware of its strategic dependencies and the fragility of its industrial fabric. So how do you think Europe can regain its strategic autonomy, or its, we can speak about its technological sovereignty, particularly in front of the Chinese, Indian and American giants?
That's also a big question. Well, there are multiple dimensions to this. One, and I think you brought that up, is the role of antitrust or competition law. I don't think that it is a coincidence that a lot of the Googles, the Apples, the Facebook are in litigation before our court pursuant to decisions by the European Commission, which has competence in these fields. We obviously have somewhat of a more clout or a different policy view in Europe as to the emergence and the actions of dominant firms. And obviously our competition law and rules and merger of acquisitions may also take those issues into consideration. As to production is Is protectionism the right answer? Not sure. I do come from a small member state, which is widely open to the outside world. I think we also need leadership more than anything else. Political leadership, not only in Europe, but at a global level. I don't think this crisis can be solved anywhere else, but through political leadership at the global level.
Thank you for your answer. And I would like to ask you a more actual questions, maybe more based on actualities and news. So the United States has recently taken strong measures against several Chinese companies and leaders involved in the repressions of Uyghur in China, while several million members of this Muslim minority are secretly detained in camps, which are claimed to be something else than camps by Peking. These laws allow for a ban on entry into the United States, the freezing of the assets of those concerned, and a commitment to prosecution. There is an advanced discussion at European Union level to adopt a directive that would allow these precise instruments to be used against people in authoritarian regimes, who are convinced that they have participated in serious criminal and political acts. My question is, what measures and behavior should be adopted, and how far can actually go the European Court of Justice, given that the country concerned is not a European Union member?
Well, there is a number of cases and measures being taken called restrictive measures or sanctions against both third country member states and individual persons. Our role is to ensure that the rule of law is observed when such measures are imposed. So I would like to take somewhat of a pass on your question, because I will be at some point probably seized if such a law is passed, with checking that whatever decision is taken is taken legally. So I don't think it is the role of a judge to have an opinion on what should be done. I'll check what will be done and ensure that the rule of law is observed if it is done.
Okay, so I think we'll go back to Europe then. We are living in a growing climate of Eurocepticism. So more and more governments or people are becoming Eurosceptic. So how can we guarantee in this anxious climate the respect and transmission of European democratic values and institutions in the face of governments that refuse any community action or solidarity on certain issues?
It's a vast question. I had the privilege as a barrister to defend the Swedish building trade union against what was perceived as undercutting of wages. It's called the Laval case, which I lost before the Court of Justice. The issue in that case was basically a simple principle. It goes back to somewhat the topic of my introductory speech: equal pay for equal work, or whether one should compete on wages, or whether there should be a solidarity to that effect. I think we need to recognize the fact that globalization does not only have winners. There are large chunks of the European citizenry that may not necessarily have benefited from globalization. So the fact that there is a reaction, to my mind, is normal. Our leadership, our political leadership in the member states and or in Europe address that issue? Maybe not enough. From the court's perspective, I think that if you look at the case law of the Court of Justice, I think there has been a realization that the internal market must also be balanced with a social pillar, with some form of social fairness, because if it is not, a race to the bottom will lead to Eurocepticism, and it has led to Eurocepticism. We have been faced with rather important shocks in our near neighborhood. That also obviously goes to the fact that the European Union has to show its added value to its citizenry. If it doesn't, it becomes devoid of purpose. So by addressing those issues, I think the Euroscepticism, to some extent, I can understand it. It can be understood, and some criticism is legitimate. I think answering that criticism is a way forward. I don't think there's any other way but deliberating and actually addressing the issues in a democratic way, in a democratic forum. Obviously, with the COVID crisis, one of the big losers have been our possibility to deliberate, our possibility to talk to each other at the national level, at the local level, whether it is in the Bierstube or at the cafes in wherever parts of France you may come from, or in the family dinners. So that, I think, is the biggest challenge we face right now. It is to take up the thread of a democratic deliberation. And that is going to take time because we've been put not on mute, but on hold for a long time to that effect.
And taking your answer, speaking about the COVID-19 impact on legal process and actions of the European Court of Justice. So you explained the impact it has, and what were the solutions proposed by you or the court in general to keep the process active and keep the debates and different discussions possible?
I think we need to acknowledge that we are slowly emerging from a state of emergency. I think law was passed in France today, maybe, trying to get out of the emergency, whereby, as in any emergency, basically it is the legislator who forfeits power to the executive. So a lot of power has been in the hands of the executive branch. During periods of states of emergency, there are abuses of power. Fundamental freedoms are at stake and can be violated. So obviously, there is a role for the courts. We play the long game, the long time. You know, we are watchers of the longer time. So there will be a period where I think the judiciary will have to step forward. It has in a number of member states. So I am quite optimistic that things will change and that the democratic debate will take over and will come back.
Now, if we talk a bit more about the general process of reform that is happening in EU courts, what do you see personally as major problems that the CJEU is currently facing, and what would be major future reforms to aim for?
Well, as anyone, we have had our internal challenges with not being able to see each other. So at the micro level, picking up, and we are a deliberative body. That is what judges do. We deliberate. Takes time, and having a deliberation over an audio call or a Skype call or WebEx is not the same as seeing each other eye to eye. So obviously, with the vaccination, picking up the deliberation in person is, to my mind, the most urgent step, and I hope that we will be back by September in person at the court, and also with the parties present. As a barrister, I always tried to convince my younger associates that, if they don't pass the blush test, they can't make an argument without blushing, they probably shouldn't make the argument. It's difficult to see someone blush on a WebEx or a Zoom. So when we have hearings by video conference, it is not the same as being in a courtroom. Our court has gone through a rather drastic reform. We have doubled and increased the number of judges from 28 to 56 and then 54. Our biggest challenge is probably the level of judicial review, the scrutiny of commission decisions, especially in the more complex economic cases. I think that is where we will have to prove our worth in the forthcoming years. And we are facing a lot of rather significant antitrust cases, and that is on the standard I think we should be judged.
According to you, should a new division of competences between European Union courts be considered, and what place should be given to specialization in juridical and law within these courts?
I'm personally, and I'm not speaking on behalf of the court here, I am personally in favor of specialization. I think a lot of the more economic cases have reached such a level of complexity that we also need somewhat specialized, not judges, because it takes a village. For any competition case, you would need competition lawyers, you would need general judges, you would possibly even need criminal judges assessing the facts and the evidence. So I am in favor of specializing chambers, in particular for anti-dumping cases, state aid cases, and competition cases. That view is not necessarily shared by everybody on the bench. We have taken baby steps in my court. So we have specialized in the least complex of cases, which are trademark cases and civil service cases. But we have deferred the decision, and we'll discuss that once we're back in presence, whether we should take a next step towards specialization. Specialization, on the other hand, doesn't solve every problem. There is a movement in antitrust law between law and economics. What is the place for judges and law, and what is the place for the regulator? And basically, should we at the European Union go the same way as the American antitrust discussion, which is currently rather vivid, whether this new, more economic approach, the Chicago School, which has had great impact on American antitrust, whether that is necessarily transposable and applicable in Europe. If you want the keyword there, should we judge all the antitrust cases by a consumer welfare standard? or should we have a broader view? So far, my court and the Court of Justice has taken a broader view, that the European blend of antitrust has its ultimate goal, the well-being of the European Union. And it's not only the benefit of the consumers.
Thank you a lot. I think it's time now for the questions of the public. So if anyone has a question, don't hesitate to ask it on the platform, especially on TUM platforms. And if not, we can go on with questions. Maybe we'll wait a few seconds just to see if someone has something to say. And if not, we'll go on maybe with other questions we do have with Carla. So Bertie, I don't know if you received any questions since I don't see the platform. Okay, so maybe if there's no question right now, I can go on. What I think could be interesting to talk about is you mentioned having your own opinion, which isn't representative of the court and the board in general. How hard is it to work with a whole member and a whole like group of different person who has their own opinion but has to deliver like a verdict at the end of the day, which is the same for everyone? So how hard is it to like work with others, especially at the European Court of Justice?
It's a challenge, of course, having been self-employed and entrepreneur, coming to the court, and I knew what I was doing. So that is, the big challenge of actually finding a common opinion among judges who will not necessarily share your legal culture or the notions. So that is, the passion of the work, of trying to understand each other and forming an opinion. On that note, I said it doesn't necessarily reflect the opinion of my colleagues. We will see about that. There is obviously one thing that we could possibly reform at the court. We are at the time being using a rather technical language. I'm not sure that anybody else but the lawyers representing the clients really understand what we mean. So I think there is an effort from the European judiciary to speak in plain language, to be clearer. Where I come from, individual judges also can express a dissenting opinion. That is not the culture of this court, which is more based on French administrative law, that the court speaks of authority. So therefore, there is only one opinion given. The minority report or the dissenting opinions, which do exist, they are just not published. So I could also see somewhat more of an openness to that effect, but that is also probably far ahead in the future. I note that the court, European Court of Human Rights in Strasbourg, does allow dissenting opinions. We don't, because we believe that that would jeopardize the authority over judgments. My view is the opposite one. I think dissent is part of our European motto, unity in diversity. Having a dissenting opinion, I think, is a rather European notion, to be honest.
Thank you. We have now a question from a student. Is the war against state aid still relevant nowadays? Is that the relative economic success of the Chinese system a proof that it could be useful to the public interest? I think there are two questions.
Could you repeat the question?
Yeah, I think there are two questions in one, so I'm going to ask the first one first. Is the war against state aid still relevant nowadays?
Is the war against state aid still prevalent?
Relevant.
Relevant.
Relevant. Sorry.
I don't know if there was ever a war against state aid. I mean, state aid, the rules of state aid when I started as a competition lawyer was something that the cat had brought in, basically. That is what you didn't want to do in a law firm because obviously antitrust was much more interesting, let's put it that way. I think that changed with the financial crisis in 2008. I think there were meetings in the European Council where basically there were suggestions of saying, let's do away with the state aid rules because now we need to act. That lasted maybe for a couple of weeks. Then they realized that, just pouring money and everyone by itself is not going to solve the crisis. So state aid rules since 2008 has become very much the center of policy making. So I think we have to find the right balance, obviously. And our role is more into the review of whether there is state aid or not. I think there is a wide margin of discretion as to what aim would one want to attribute state aid. With the COVID crisis, obviously, parts of the economy is under perfusion, and without the intervention of public funding, I think a number not only of airlines but also small business would probably have gone under. So that brings me back somewhat to the issue of solidarity. Then somebody has to pick up the bill at the end of the day. So that is going to be the next debate, is more how will we finance this, because there has been exceptional measures. I don't know, the French notion was at any cost, coûte que coûte. Well, sometimes or at some point, we also have to pay the bill. So my prediction, it's probably taxation that is going to be the next big thing, because we obviously need to find the means to finance the solidarity which has been shown during the past year and a half. And the second question was about China, is that correct?
Yes, so do you think that the relative economic success of the Chinese system is somewhat a proof that public funding could be useful to the public interest? But do you think that the Chinese system is a system that we should follow as in the European Union in terms of their economic?
In terms of a political system, I would rather live in our political system than in the Chinese. Obviously, the Chinese have had success, economic success with their system. I think I would rather pass on the question.
Okay, so we have another question coming from Valentin. So thanks, Valentin, for your question. Given the fact that some countries like Hungary or Poland mostly block some progresses within the European Union, and the fact that the European Union could be even more integrated in terms of law and justice, what do you think about a two-speed Europe?
What do I think about the two-speed Europe? We do have a multi-speed Europe. We have a 2- or 3-speed Europe already. My own member state is not part of the Eurozone. So we obviously do find ways of allowing those who want to go forward to go forward. The question is, can we can we have divergent views on fundamental values? And I think that is the underlying question here, that at some point we can obviously have a discussion about it. But as any community, any Gemeinschaft, we need to have a common set of values, and that is what is at stake right now. I think I will stop there on my comment. But at some point, if one doesn't share the values, you can either try to change them, or as the case in the Great Britain, obviously you can leave. That is options on the table, and I do not wish anybody to leave. So let's have a discussion about the values. But we can't deny the fact that if we're going to have an open Europe, we do need a common set of values on which we agree upon.
Thank you for your answer. This will be our last question. Maybe you could say a few words to end the conference.
Well, thank you. Thank you, and basically stay safe. I think I've said that, you know, you are the next generation. I did thank you for the solidarity you have shown. I think it's also time to look forward. And with your energy and optimism, I think, you know, I am optimistic about our common values in Europe. But they need to be defended. And I think that is the task of each and every one of us. So thank you. Thank you very much.
Thank you for coming. We're very glad to have heard you today with your great message on solidarity, especially.
Thank you.
Have a good evening, and goodbye, everyone.
Stay safe.
Thank you.